Good morning and welcome to the May 25th, 2023 Law and Regulatory Commission meeting. At this time, I'll call the meeting to order and have the clerk call the roll.
Vice Mayor Bernasconi.
Here.
And Councilmember Mendonça.
Here. Amber Blix, would you please lead us in the pledge?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Amber. At this time, I will open it up for public comments. Seeing none, I will close public comment. Bring it back up here to discuss the minutes from the prior meeting. Vice Mayor Bernasconi, do you have any amendments or updates?
No changes.
Awesome. I don't either. At this time, then, I will motion the approval of the minutes.
You want public comment?
I'm sorry. I'll open for public comment on the minutes from April 27th. Seeing none, I will close public comment and ask for a motion to approve the April 27 minutes.
So moved.
Second.
And so we have council consensus to approve those minutes.
Thank you. Okay, at this time, we will move on to the first item on our agenda this morning, item 6.1, state and federal priority legislation, and I will move it over to Mark Lewinsky and Rob Becerra.
Thank you. Good morning, Chairman Donza and Vice Mayor Bernasconi. Once again, I'm Mark Lewinsky, Government Relations Administrator, and I'm joined this morning for today's presentation by Rob Becerra, Program Manager in Public Affairs in the Communications Department. The following report includes an overview of several bills and areas of particular focus on public safety, information technology, and planning. And at the federal level, the debt ceiling limit discussions. I'll turn the presentation over to Rob, who will provide an overview on the public safety bills.
Thank you, Mark. Going to discuss today 6 pieces of legislation, and they are issues that we continue to track and that you've previously heard of or we've discussed, and just wanted to provide you an update, a bit of their status. We are now moving into the space where we're starting to support and oppose pieces of legislation, actively moving their way through the process. The first bill that we'll discuss is SB 796, Threats Against Schools and Places of Worship. We are supporting this bill because currently today there is no victim when someone threatens a school or place of worship. And this bill adjusts the language where someone can actually be held criminally accountable for calling it a threat where someone feels as if they are threatened. And so this, we hope, will help to quell some of the rise in many of these cases that we are seeing. Next bill is AB 793. This is privacy and reverse demands. We are opposing this bill, and it is it's a extremely nuanced bill that is being carried under, I'll say, different circumstances to the impact that it would have on law enforcement. And I'll explain what that means. Is this bill effectively makes it so that law enforcement cannot track someone's cell phone. So the current process for tracking someone's cell phone is a judge has to issue an order. The investigating agency has to go to that cell phone company, Verizon, and then ask for those pinpoints on that cell phone. Now, we can think of criminal cases that are very widely in the news right now where we can see that plot map to say this suspect was in and around this house, at the exact time of the incident that occurred. So the challenges that this would create for investigative purposes, basically getting rid of the ability to do that reverse search on someone's cell phone ping, would create significant challenges for our detectives. So that is, I would say, the primary reason that we are opposing this bill as it currently is. The next is SB 58, Controlled Substances Decriminalization. We are opposing this bill just because it decriminalizes the possession of a lot of hallucinogens and other drugs that we see on the market, and we feel like this would just create a negative space for people to not be held criminally accountable being in possession and selling of drugs. Next is SB 94, recall and resentencing special circumstances. This one, we are I would say, supporting our partners in the county who are strongly opposed to SB 94 because it truly would allow anybody who is currently incarcerated with on a sentence of life without the possibility of parole. All of those cases would effectively be up for reconsideration, and it would create just a significant demand on the system where there is a long-running system of how do we get people out of incarceration, and we feel like this is a negative way to identify a large group of people who would now become eligible for not being incarcerated anymore. So we're keeping a watch position on this because we do feel this is primarily a district attorney fight, but we're making you aware of it because it is something that we are tracking. The next two pieces are items that we have discussed before in length with a slight bit of an update. Both of these, AB 742 and SB 50, fell into the suspense file. We continue to track them. Amendments were made. Both of them have actually moved out of the suspense file. I'll call specific attention to AB 742. This is law enforcement use of police canines. We are doing significant advocacy on this piece in opposition because one of the amendments that was recently made was to shift the use of a police canine to be under the definition of use of deadly force. And that potentially opens this wide range of now liability on the city's part. Whenever an officer uses a canine in the course of duty, that is now, this piece of legislation would effectively move that into the use of deadly force category, which obviously comes along with other significant ramifications. So we were on the phone yesterday with Assemblyman Patterson's office, just discussing our belief that this is a really bad bill. Their office is in full support of that and will do what they can to carry the message forward. So at this time, there's the status for those two pieces of legislation, and with that, we're going to continue to stay engaged and work collectively in the government relations team to advocate for those items we feel of most importance. With that, I'll turn it back over to Mark.
Thank you, Rob. And I'd just like to add to the canine bill, we also spoke with our state lobbyist, and he's indicated that the bill does have an uphill climb to get not only off of the assembly floor, but if it does move off of the assembly floor over into the Senate, that there'll be some challenges for the bill in the Senate as well. So it's not a bill that is a slam dunk to be approved and move forward. So I just wanted to provide that additional information. Several bills with respect to information technology. Assembly Bill 1637, which is local government internet website and email addresses. Cities opposed to this bill. The bill would require local agencies that has an internet website for use by the public to ensure that the internet website utilizes a .gov or a .ca.gov second-level domain. The city has taken and opposed, and that for email addresses for its staff would have to have the same designations, a .gov or a .ca.gov extension. The city has taken an opposed position on the bill for an assortment of reasons, including cost to implement these changes. While applying for and securing a .gov domain has no fees, there are associated costs to all of the other changes that would need to take place to business cards, vehicle decals, websites, new corresponding email addresses, and the like. In addition, all of these costs are increased twofold to coexist both the previous and the newly acquired domains. So we've taken an opposed position on this bill. With respect to AB 740, I can let you know that since the staff report was written, this bill is not moving, so I won't take the time to to share that information with you on the bill. So for this session, the bill is dead. Senate Bill 265, cybersecurity, preparedness, critical infrastructure sectors. We're watching this bill. The bill would require Cal Office of Emergency Services to direct the California Cybersecurity Integration Center to prepare and for Cal OES to submit to the legislature on or before January 1st, 2025, a strategic multi-year outreach plan to assist critical infrastructure sectors in their efforts to improve cybersecurity and an evaluation of options for providing grants or alternative forms of funding to potential action, voluntary actions to improve cybersecurity. So we are, the city's chief information officer and IT staff are currently participating in a statewide cybersecurity plan. And so they're deeply engaged in that process. And so we're looking at this bill for the opportunities of how staff could provide input into this process if the bill were to go forward and the requirements were enacted. With respect to planning, AB 350, the Regional Transportation Plan, the Sacramento Area Council of Governments, we're supporting this bill. It would require the updated Regional Transportation Plan, Sustainable Community Strategy, and Environmental Impact Report adopted by the Sacramento Area Council of Governments, or SACOG, on November 18, 2019, to remain in effect for all processes until the SACOG adopts its next update to its Regional Transportation Plan. We're supporting this plan because the bill would facilitate greater interregional collaboration by more closely aligning SACOG's Sustainable Community Strategy update with those of its regional partners, the Metropolitan Transportation Commission and the San Joaquin Council of Governments, both for SACOG's current plan update and into the future. With respect to AB 519, Affordable Housing Finance Work Group, this city has taken a support position on this bill as it would require the development of a consolidated application and process for applications for affordable housing grants, tax credits, and other funding sources. The state system for funding affordable housing creates unnecessary complexity and delays the development of affordable housing. A unified application and coordination review process would reduce the cost of development and expedite the funding application process. And then finally, with respect to AB 978, similar to the previous bill that I mentioned, since this report was written, the bill has failed and is not moving, so we'll pass on that bill. And then finally, with respect to at the federal level and the debt limit ceiling discussions, when I wrote the report, the information that you see on the screen is what was timely at that moment. I can tell you that since that time, that the White House and congressional leaderships are preparing for another round of discussions on government spending and the debt ceiling. Debt ceiling talks have continued, but there has been no change on the impasse. After fresh optimism following the last face-to-face meeting between the President and the Speaker, the two sides still remain far apart on several key issues, including long-term spending caps, the length of the debt ceiling hike, work requirements for federal assistance recipients, and fiscal year 2024 appropriations, among others. With talks poised poised to slip into the latter part of the week. We're there. And that we've heard today that Congress will be leaving Washington tonight. Any sort of debt ceiling agreement prior to Friday is becoming increasingly unlikely, despite the potential June 1st X date. I can also let you know that we've been talking with our Housing Authority staff because, as you may recall, the GOP bill to hold spending limits at current levels and then reduce spending limits in other areas was determined to create between a 20 to 25% reduction in certain programs and services and departments and agencies programs and what they're able to offer. With respect to our housing authority with HUD, where we have incredibly important programs such as our Housing Choice Voucher, our Community Development Block Grant, we're asking staff to be prepared to give an accounting of what a reduction would mean to those programs. We know that we have 795 Housing Choice Vouchers that are currently active that are providing rental assistance to our members of our community, residents in our community. And so we want to be prepared to be able to share with, not only with council, but with the community and others, what those implications would be if there is a reduction to the HUD programs. And so with that, concludes our presentation, and Rob and I are prepared to answer any questions you may have.
Thank you, Mark. Thank you, Rob. Vice Mayor Bernasconi?
You said you're prepared to answer any questions. What about keeping us up at night over this proposed legislation and our debt ceiling? My goodness. But specifically, we talked about the why when it comes to the police reform or police public safety bills that are out there. We talked about the why for AB 742 and SB 50 the last time that we met, but I'm curious the why on 793 and SB 58. I mean, just in a nutshell, is there a why around why a legislator would think that it's a good idea to remove the ability to track suspects, or why would it be a good idea to decriminalize controlled substances? I know that's a big question, but I just am curious the other side of that.
I will start with, I'll start with AB 793, and this is the reverse demand, and it is the overarching would be privacy. So the intent of the bill came out in regards to the conversation around reproductive health and someone's ability to track where potentially someone went between state lines, and that ability to determine where that individual was, and could that be used to hold them criminally accountable based on healthcare rights. That's how the bill was introduced. Now, I think we see the downrange ramifications of law enforcement's ability to track someone, and we see it on the side presented here, which is that inability to track somebody who we truly believe commits a crime, or pinpointing around that certain location, home,
Okay,
that had that incident, to see who was around there. And so I think it is that downrange ramification, but the nexus of that bill came out of that conversation.
Okay, thank you.
For the others, I think it is just the pattern that we are seeing in decriminalization to attempt to reduce our prison population.
Okay, all right, that helps. Thank you.
I also had SB 50 on here, Rob. I just was wondering, it was on our agenda from last month as well. So I know you didn't elaborate on it too much when it came up in your presentation, but what's been the difference or the movement since last month?
Excellent question. And I would say we felt very strongly that this one was not going to move forward. And in fact, I can't hit on the specific amendments that have been made, but we do see continued traction around it. So it's something on SB 50, vehicle enforcement, we can circle back and see what amendments have been made to it that is continuing to push it down the road.
Okay, yeah, I was just curious. Thank you. And then on AB 519, it's nice to see that this will help expedite that process. What you presented, Mark, I think that's good for those people that need that. So thank you for your presentation. Okay, next I will move on to, I'm sorry, we have public comment. So I'll open it up for public comment. Seeing none, we'll close public comment. And we'll move on to item 6.2, our electric department priority legislation. Good morning, Amber.
Good morning, Chairman Donza and Vice Chair Bernasconi. Before I get into the legislative bills that we'll be tackling today, I did want to discuss some of the recent activities of the electric department. Yesterday, we had the opportunity to have our director speak at an informational hearing in the Assembly Utilities and Energy Committee on distribution planning. And we were on a panel with the California Public Utilities Commission, the California Energy Commission, PG&E, a representative from Humboldt County, a supervisor up there, and then also a representative from the home builders in the Chico area. So we thought this was a really great opportunity for us to showcase some of the great things that we're doing in Roseville. And our director talked about kind of just a general distribution 101 of kind of how we operate here in Roseville. We talked about some of the growth opportunities that we have in Roseville and how we're planning to meet the state policy goals. We also were able to collaborate with our trade associations, CMUA and NCPA, on those comments, as Dan, our director, is the president of California Municipal Utilities Association. So it was a great opportunity for Roseville and also a great opportunity for us to sit in the spot of the publicly owned utilities on the panel. I will say that I think it really was a great opportunity for us to showcase what we're doing here, because at one point, one of the legislators on the panel really kind of, to sum up what he said, was Roseville really gets it. Roseville has it going on. So I think that was a great opportunity, and I hope we have the opportunity to have more of those conversations in the future. So just wanted to brief the committee on some of those activities that we've been having down at the Capitol, aside from on legislative topics. So in going over our legislative and regulatory overview for this month, I'd like to talk about, on the state side, some broadband permit application legislation. We'll also talk about a bill that deals with Local Electrification Planning Act, a streamlining bill on funding opportunities, renewable generation and transmission rights of way, and also a bill on neighborhood decarbonization program. And then two bills at the federal level, including the Supply Chains Act and the Investing in Our Communities Act. So first is AB 965 on broadband permit applications. This bill is similar to many of the bills that we've seen come before us in the past on broadband permitting. This bill would require local agencies to undertake batch broadband permit processing, and it does allow us to limit how many could be in one batch, but they can't be less than 50 in one batch. Yeah, so the limit is not really much of a limit, I would say. The permits would be deemed approved if the response is not granted in a reasonable time. I don't believe that the bill defines what reasonable time is at this point, so that's something that we'll also be continuing to watch. And then for us, from the publicly owned utility perspective, this has just always been one of pre-consultation process with publicly owned utilities, which this bill is missing, and then continued concerns regarding pole loading on our utility poles for these devices. So this is one that we are opposing right now through California Municipal Utilities Association, and this is a bill that has a lot of politics involved in it in terms of connecting folks, seeing that folks are interconnected. So we are continuing to oppose this through CMUA at the current time. The next bill that we have on our list is AB 1164, related to the Local Electrification Planning Act. This would require cities to adopt a climate action electrification element as part of the general plans. And the goal there is to meet greenhouse gas emission reduction goals and increased electrification targets. This would require the city to amend the general plan and adopt it between January of 2025 and January of 2028. And it would need to address key items, including setting goals for implementing electric vehicle charging stations, identifying barriers in city codes to meet EV charging needs, setting goals for electrification of new and existing buildings. We have a watch position on this bill currently. I think a lot of these things are components that the electric department is already looking at. So we expect that if something like this were to pass, we would work very closely with other departments in terms of how this would be implemented. But continuing to watch this bill at this point to see if it continues to move through the legislative process. The next bill is AB 1182, and we are in a support position on this bill. This bill would require the Governor's Office of Business and Economic Development, or GOBIZ, to identify opportunities to co-fund grants for climate goals. They would collaborate with state agencies to maximize funding, streamline incentive opportunities on one internet website, and then report these opportunities to the legislature by February 1st of 2024, as well as reporting awards from the Inflation Reduction Act and the Infrastructure Investment and Jobs Act by May 15th of 2024. And then this bill would sunset in January of 2033. We think that this bill is helpful. There are so many funding opportunities right now, and they're coming from so many different avenues. So if we could actually streamline these all onto one website, I think that would be helpful for folks like us that are trying to identify and go out and seek funding opportunities. And then this is actually really looking at maximizing the funding that California can get out of the federal government programs that have been issued so far. So we think this is a helpful piece of legislation. The next is SB 49 on the Department of Transportation strategic plan. So this would require the Department of Transportation, or DOT, to collaborate with the Energy Commission and the Public Utilities Commission to develop a strategic plan by 2025. And this is to lease and license department-owned rights-of-way to public utilities to build and operate renewable generation and transmission. As part of the strategic plan, they would have to establish goals for this renewable energy generation capacity to be leased by 2030 and 2045, and then also identify right-of-way corridors aligned with increased energy needs, and establish an application process for land use agreements. We like this bill generally, but are taking a watch position on it. We think it makes sense. The state is going to need to get a lot of capacity online to meet their energy targets by 2045. So using highway rights-of-way or existing corridors through the Department of Transportation might be a really unique way to kind of facilitate some of these goals. So this is one we have as a watch, but generally think it's probably a good idea. In terms of the next bill that we are tracking, SB 527, this deals with neighborhood decarbonization. And it looks really at a pilot program. So it would require the California Public Utilities Commission and the 3 largest gas corporations to develop and supervise the neighborhood decarbonization program. It would facilitate cost-effective decarbonization of natural gas zones. As I mentioned before, it cannot exceed 15 pilot projects across California. The PUC will have to develop processes to determine if the gas service may be discontinued to customers participating in the program. And then by 2025, they would need to submit a progress report to the legislature. And this bill would also sunset at the beginning of 2030. I think right now we don't see this bill as impacting Roseville too much, as it is a pilot program and it should be very small. However, we're going to continue to watch to see how this bill moves forward through the process. And then finally, on the federal front, there are 2 bills that we are supporting. The first is H.R. 763, which is the Supply Chains Act. This bill establishes an Office of Manufacturing Security and Resilience in the Department of Commerce. It would require the Department of Commerce the Department of Commerce to assess and create a strategy to counter threats to critical supply chains. And then every 4 years, they would have to report to Congress on critical supply chains. We like this bill. We think that it may be an avenue to address distribution transformers, which I know you have heard have been having supply chain issues as of late. And this would prepare them for future supply chain issues as well. So we're looking to support this bill. And then finally, H.R. 1837, the Investing in Our Communities Act. This bill is bipartisan legislation to restore tax-exempt advance refunding for municipal bonds. It allows the department to save money and interest costs by refinancing outstanding debt to a lower interest rate. Allows governments to take advantage of favorable market conditions to reduce borrowing costs. And it could be a financing tool to stimulate economic development, create jobs, and save taxpayer dollars. It also reduces borrowing costs and frees up resources for other energy projects in the future. So this is one that we are also supporting through the American Public Power Association. And that gives a snapshot of some of the bills that we're tracking right now, and we're happy to answer any of the questions that the committee may have.
Thank you, Amber. Vice Mayor Bernasconi?
I don't have any questions. I always appreciate the feedback and hear it myself about like Roseville getting it. Tracy and I had an opportunity earlier this week to meet with the director of the utility, Dan. That was really helpful and informational too. So thanks for the update.
I just had one question, and you may not know the answer to this, but I know on HR 763, when I was reading through it, FEMA has always had their own inventory and surplus management, the stockpile, certain items that are always necessary during times of emergency. Will this HR 763 bill be in addition to that, or will that be blending that already supply chain inventory surplus management process into like a larger idea?
I don't recall FEMA being mentioned in the bill, so I think this would be in addition to it, but I'm not 100% sure of that. So just how I would read the bill, if they're not mentioned, I figured it'd be
It just
in
sounded like there
addition.
might be some redundancies in there. I was just curious if there was any discussion of a blend or if they're going to remain separate. So anyway, just thought I'd ask if you hear of any of that, please.
Okay.
I'd just be interested to know.
Okay.
All right. At this time, I will open it up for public comment. Seeing none, I will close public comments, and we will move on to our next item, item 6.3. I'll welcome Michelle up. Good morning. Or Noelle, what did I say, Michelle? I looked over at Michelle as I was talking. Good morning, Noelle.
Good morning. Good morning, Chairman Donza and Vice Mayor Bernasconi. We're approaching the halfway mark in this year's session. In this first half, staff has identified 253 bills that could impact our utilities within EU, and we have actually engaged on 39 of those bills, either in support, opposition, or seeking amendments. This morning, I will be covering state legislation dealing with drought, water rights, per and polyfluoroalkyl substances, which I'm going to say PFAS from here on out. And then I will provide you an update on the Advanced Clean Fleets regulation, and I will close with federal legislation that we are supporting. The first bill is AB 1572. This bill establishes a tiered implementation for the prohibition of the use of potable water on irrigating what they're terming non-functional turf. So beginning on January 1st of 2028, local governments, regional public agencies, and public water systems would be prohibited from using potable water on those non-functional turf areas. Then on January 1st of 2029, it would extend to commercial, industrial, and institutional entities. And then on January 1st of 2030, it would extend that to multifamily and HOA common areas. Affordable multifamily housing units and disadvantaged communities would be the last, and that would happen in 2031 or whenever the state makes funding available for conversions of those landscaped areas, whichever is the latter. Coming out of fiscal committee, the bill was amended to address a lot of the concerns that have been expressed by the water community. The amendments also addressed our concerns for being able to protect our tree canopy. That was one of the biggest issues. We wanted to be able to make sure that we could continue using potable water on street medians and in other areas where we have trees, and there is not recycled water available. The amendments also added new definitions to define functional turf and non-functional turf. Staff are concerned with the new definition of functional turf, specifically because of the reference to turf enclosed by a fence. Speaking broadly, it could potentially apply to our sports fields if there's a fence around it. And so staff is working with our statewide associations and crafting amendments that we'll be putting forward on this. The next measure is SB 676, which the author's stated desire is to discourage the use of artificial turf because of PFAS. So to achieve this goal, the bill seeks to encourage the use of living plants by prohibiting cities and counties from enacting new or enforcing current ordinances or regulations that ban the installation of living drought-tolerant plants. It also repeals our local agency's ability to impose reasonable restrictions on the type of drought-tolerant landscaping that can be used. Now I'm moving on to a much more controversial and meatier topic, which is water rights. And I'm going to be giving a very high-level overview based upon my understanding. There are so many nuances that we're learning new things as these bills are amended. But this year there are several bills that are working their way through the legislature that really upend the current water rights system. The authors of the measures have taken a stance that the current water rights system is prejudiced because the early water rights were obtained during a time when people of color were unable to own land. So it is important to note at this point, too, that while Roseville does not have our own water rights, we do contract with the Placer County Water Agency. So Roseville is coordinating our efforts on these bills with our partner, PCWA. Before I jump into the bills, I would like to share some just general overview information about California's water rights system. There are several types of water rights: riparian, prescriptive, or appropriative. Appropriative rights are broken down to pre-1914 and 1914. That 1914 date is significant because that's when the Water Commission Act was enacted, and anyone after 1914 has to get a water right permit in order to use water. The State Water Board has the ability to curtail the use of post-1914 permit holders, and in more recent years during an emergency drought declaration, the board issued curtailment orders to pre-1914 water rights holders. And as a result, there were lawsuits. Current civil penalties for violating an order of the State Water Board is $500 per day, so not very hefty. And the State Board has to rely on the state's Attorney General to petition the courts for injunctive relief on their behalf. So it is a choice, and it ends up becoming a political game between the State Water Board and the Attorney General. So with that very basic overview, I'll jump into the bills. And the first one is AB 460, which expands the State Water Board's authority to initiate interim relief proceedings on its own or by an interested party. It also increases the civil penalties for violating interim relief orders from that $500 to $10,000. And then it removes the discretion of the AG to decide whether they will seek injunctive relief for the State Water Board. The next measure is AB 1337. This bill is in response to the appellate case decision on the Water Board's authority to curtail senior water rights holders during the 2015 drought. I had mentioned before there were lawsuits. This is in response to those lawsuits. The court found they did not have that authority. However, in the decision, it invited the legislature to opine on that policy by stating whether this approach to water rights in California represents sound policy in a time of increasing water scarcity is a question for the legislature. So in response, Assemblymember Wicks introduced AB 1337, which would grant the State Water Board with the explicit authority to curtail those senior pre-1914 water rights holders. Failure to comply with a curtailment would become a trespass and open them up to fines and penalties. And then this measure would also provide the Water Board with new authority to issue cease and desist orders. The last water rights bill is SB 389. This bill seeks to address a Planning and Conservation League report that argued that the Water Board does not have the tools to promptly investigate and determine whether a senior water right claims are inflated or represent the amounts that they have the right to actually divert and use. It does so by allowing the Water Board to investigate the diversion of water to determine the basis of the water right using the public trust doctrine. Any investigation, the onus would be placed on the water right holder to prove their right to the Water Board. If you can imagine, documentation from pre-1914 is probably limited in some cases. And lastly, it would allow the Water Board to issue a decision or determination that the diversion and use authorized under what they're claimed right, they do not have any basis. So that means they could strip the most senior water rights folks of their water rights. All of these measures will cause uncertainty in the water rights system, and this uncertainty really could have a chilling effect on the ability of cities and counties to continue building housing, because you have to have water to serve, and if your water right or your water sources are in question, you really, it would be difficult to move forward with new housing stock. The last measure that I'm going to talk about this morning for the state is AB 1423, which seeks to ban the use of artificial turf and synthetic grass that contain regulated PFAS. So beginning in January 1st of 2024, public entities, including charter cities, public and private schools, and public and private institutions of higher learning would be prohibited from purchasing or installing artificial turf that contains PFAS. Then, as of January 1st, 2025, this measure would prohibit the manufacturing or sale of artificial turf that contains PFAS in California. So at this time, it is believed that all of these synthetic turf and grasses contain PFAS. So EU is coordinating with MARC on this legislation as it moves forward, and staff does recognize the beneficial use of these types of fields by the Parks and Recreation Department, as well as the tourism Roseville enjoys from our fields. So moving on, last month, Sarah filled in for me, and I heard she did an amazing job. So, but she did so because I was down at the Air Board hearing on the Advanced Clean Fleet regulation. The following day, on April 28th, the Air Board adopted the Advanced Clean Fleet rule. This was actually after probably about 10 plus hours of testimony the day before. As we've shared with the committee previously, Air Board staff was directed to address the unique situation faced by agencies like Roseville, tasked with complying with the short-lived climate pollutant regulations, and have done the right thing and put organics to a beneficial use. In the end, what Air Board staff crafted did not address our concerns, and leading up to the hearing, EU staff worked with the California Association of Sanitation Agencies, more commonly referred to as CASA, to coordinate our testimonies. The evening prior to the hearing, the Air Board released a resolution aimed at providing additional direction to the CARB staff on the implementation of the regulation. The resolution also again tried to address our concerns, but it fell short and directed the highest and best use of biogas would be for pipeline injection. At that point, Roseville and CASA shifted our efforts to obtaining revisions to the implementing resolution. Working alongside with CASA and others, we were successful in obtaining amendments to the resolution that now directs the Air Board staff to work directly with CASA and other state agencies on developing markets for our biogas. Of currently, which there are none. And so we also obtained the ability to revisit our issue in 2025. This way, if there is no market that's been developed for biogas and the use as a vehicle fuel remains the highest and best use, we can argue before the Air Board to allow for its continued use in our refuse fleet. So it's kind of more of a long game. We lost in the short term, but hopefully we'll be able to get changes down the road. Lastly, there are two identical federal bills that we are supporting. They are SS 1350 and HR 2964. They are modeled after California's AB 818, which was signed into law in 2021. And AB 818 required certain pre-moistened, non-woven, disposable labeled wipes to be labeled clearly and conspicuously with the phrase "do not flush" and then have an associated logo next to it as well. Roseville was a strong supporter of AB 818, and so specifically S 1350 and HR 2964 would direct the Federal Trade Commission to develop regulations to implement a do not flush on a nationwide basis. The Federal Trade Commission also would have 2 years to develop those regulations. There was no specific time. It would just be after the bill wasn't enacted. And that concludes my presentation this morning, and I am happy to answer any questions you may have, except for on water rights. Just kidding.
Thank you, Noel. Vice Mayor Bernasconi?
I just remember Rich Plucker talking about the wipes and the labeling. I mean, this has been going on for a long time, but
Yeah.
it's really interesting around the labeling of do not flush, but, they're going to have to change their names too, right? In fact, I get in arguments with my friend when we're out, like, you can't flush those. Yes, you can. It says, no, you can't, so Rich is in my head about this stuff, but yeah, that'll be a big shift.
Yes.
I don't have any specific questions, but just always appreciate your watchful eye and your updates on this legislation and our positions.
Thank you.
I have one question on AB 1423. So in the presentation, and I'm assuming it came out of the bill, on January 1st of 24 is the notification period, and then the artificial turf is banned on January 1st of 25, or prohibited, excuse me.
Yes.
So specifically with our long field, now in about 3 weeks, we're going to be, breaking ground and doing the whole, starting the process on that. So with stand to reason, there's only 6 more months left in the year that turf probably won't go down until the calendar year 24, which would still be in the notification period. But my concern is, according to Jill, when we got the presentation on the long fields, turf life is anywhere from 8 to 10 years, depending on how aggressive the play is. So it will certainly be within the prohibited period when replacement needs to occur. What does that look like for us as far as being able to replace and repair if artificial turf is not allowed? Are we grandfathered in, or do we have to now apply for special permits and things to acquire that? Do we know?
I think that's an unanswered question. I did not see anything within the legislation that would say any current fields would be grandfathered in.
Okay. That's a little concerning, considering that when repair time comes, what do people like, or cities like us and others do, to address those issues, especially from a safety concern? Okay. I appreciate that.
It's a little bit of it's a tug and pull, because what would you be replacing it with? You'd be putting in real turf, live, living turf. And that would be the opposite of what the state is asking you to do. So it's a conundrum of a bill, if that's the way to best describe it.
Yeah, it's
But
one of
yes.
those scenarios like we see often in California that looks good on paper, but not actually something that's easy to apply, you know. Awesome. Well, thank you, Noel. At this time, I will open it up to public comment. Seeing none, I will close public comment. Mark, do you have any final thoughts or closing remarks?
Just wanted to share that, one of the important elements of, you heard Amber talk about the director testifying in committee. And this year, obviously Noel has testified, and our chief information officer has also testified in committee. And, there's a great deal of work that happens behind the scenes, for preparing the testimony and the information that's going to be brought forward. But oftentimes, I know in particular with respect to the chief information officer and with the director of electric testifying, that there is coordination that happens with our state lobbyist. And, we'll meet with the state lobbyist to get his perspective and insights into the testimony, into the committee. And I know that Jason Gonzalez was at the meeting yesterday and introduced the director to the chair of the committee. And so I just wanted to make the committee aware of that additional work that happens in the background that, we don't see during the committee hearings, but to help you understand and recognize that additional work that happens and that coordination that happens with our state lobbyists. And on the federal side, that same type of coordination would happen on the federal side if there were ever testimony that we were going to provide to Congress.
We are definitely fortunate in this city to have the department heads and the knowledge that they all possess. It certainly shows just in this meeting and in other areas where we all have discussions as council members with them. I mean, the knowledge and just skills that they bring, you're right, behind the scenes, we don't see it, but it obviously does come out, though, because this makes us the great city that we are. So thank you for bringing that up. At this time, I will adjourn the meeting. Our next meeting will be on June 22nd. Thank you.